Good afternoon. Mr. Reid, I think we are ready to resume. Thank you.
Thank you. I think by way of a quick overview and introduction, if not a canter, I went through our respective position in relation to the respondent's case. Can I turn then to section B, which is the section that deals with the interpretation of section 136 and whether or not it was intended and did make any material change to the way that the burden of proof was to be approached. In doing that, can I begin by addressing a point that my learned friend made? I think I'm seeing his appellant's case, and he referred to it twice in the course of submissions. And that's a passage in the judgment of Lord Justice Hooper in the case of EB and BA. You'll recollect he cites it for the proposition that in the context of a discrimination case, the respondent shouldn't act like the commercial litigator and step back and say it's for the claimant to prove. Unfortunately, that's a point which has to be seen in context. May I take your lordships briefly to EB and BA? You find it at page 596 in the bundle. That's the head note. This is a decision of the Court of Appeal, and in very straightforward terms, it was a case brought in relation to, under the precursor legislation, for discrimination on the grounds of gender reassignment, and the claimant alleged that they had been made redundant as a consequence of effectively the starvation of work when it came to selection redundancies, and they attributed the failure to provide them with any ongoing work in the business to the commencement of their gender reassignment. And the claimant lost at first instance, but eventually was successful before the Court of Appeal. And my only point in relation to it is to note this: we don't perhaps need to trouble too greatly with all of the facts in relation to the earlier part of the judgment. The passage that my learned friend has referred to on a couple of occasions is that at paragraph 52. That's on page 604. This is where he draws his observation about the difficulty in commercial cases of the commercial stance. What that ignores is the preceding paragraph, paragraph 51. And if one reads paragraph 51, may I invite your lordships briefly just to read it yourself. What's evident from paragraph 51 is that the Court of Appeal had already looked at all the evidence that the tribunal had before it and concluded that there was evidence upon which the tribunal ought to have concluded that the burden of proof had switched. That's evident in the first sentence of paragraph 51. So the appellant has succeeded in a perversity conclusion on her appeal to the effect that the tribunal had failed to conclude that the body of material before it had led the burden of proof to switch. Now, of course, in that context, it's entirely understandable why in paragraph 52, the court is looking with some skepticism, with the arguments being advanced on behalf of the respondent, that it didn't have to lead or deal with evidence about every respect, because of course the entire purpose of the burden of proof switching is that the respondent had to provide an explanation at that point in time that entirely persuaded the tribunal that discrimination was not the reason for the treatment. So it simply wasn't there for it to be selective if it wanted to succeed, because if it failed to discharge that burden, the whole purpose of the shifting burden of proof would be met. So 52 doesn't really support a generic proposition that discrimination law is in some way distinct from the normal forensic process, that one looks at the evidence one chooses to lead in relation to a particular case. Can I also follow that through in just looking at the progression? Now, in our looking at the progression of the law, in our respondent's case, from paragraph 12, that's page 105, we track through the interpretation of the burden of proof provisions, and you've heard my learned friend in relation to that. The historic approach to probably not strictly determine the burden of proof, but an evidential approach of inference drawing in King and GB China Centre, and then following the directive, the case of Bartley, Investec and Henderson, where we have the first articulation of the sequential process, which we set out at paragraph 13 on page 106. And I'm not going to go through that evolutionary process, subject to 2 points. And they relate back to the question of the way that litigation works in the context of discrimination. At paragraph 14 of our case, we refer to Egan and Wong, and my learned friend has taken you to that, in part for the purpose of looking how Egan and Wong articulated the approach to be taken and how that approach might be changed by section 136. May I take you back to Egan and Wong, and it's 652, page 652. 652, the Court of Appeal, as my learned friend indicated at paragraph 76, having heard argument, made a modification to the earlier guidance that had been given and restated their guidance in the annex to that particular judgment. And my learned friend went through the respective paragraphs. He referred to one which had to be changed as a consequence of legislative change. And it's worth just focusing on that because it perhaps underlines and makes clear that tools are still available to a claimant in relation to discrimination. Paragraph 7 of that guidance referred to what was then a statutory mechanism. So there was a statutory mechanism in all the precursor legislation whereby a claimant could serve a questionnaire, and a questionnaire formed a statement of specific questions or information directed at a respondent. And if the respondent failed to answer that information or gave an equivocal answer to it, the statutes provided that an inference could be drawn, if it was just and equitable to do so, from that failure. Now, that was in fact brought into the 2010 Act. It was originally in section 138 of the 2010 Act, and regulations were made under section 138 to create the same regime. There was a provision whereby a claimant could serve a questionnaire and a respondent had an 8-week period to reply with adverse inferences. Now, we perhaps don't need to go into the reasons for this, but a review was undertaken following a change of government after the implementation of the Equality Act as to whether or not questionnaires placed a burden upon employers. And the view was that they were being misused, and therefore that section was removed. So that's why subparagraph 7 no longer appears in any of the subsequent directions. So that tool was removed from claimants. But that doesn't mean that claimants are deprived of the normal evidential and forensic tools that any litigator has. So the Employment Tribunal rules include equivalent powers to CPR in relation to orders for disclosure, orders for the provision of further information. So, for example, if a claimant wanted to obtain statistical information as to the outcome of selection procedures for jobs and the nature of those applying for those jobs, they could formulate a question very much in the way they might have done with a questionnaire and ask the tribunal, usually at the level of the stage my learned friend indicated, of directions for the hearing of the case, for an order that the respondent provided that particular information. And equally, if they wanted to get disclosure of, for example, the applications that were made for a particular post or the CV of a successful candidate, even if the respondent hadn't disclosed those as part of disclosure, a claimant would be able to do that. So it's open to a claimant, as with any other civil litigation, and the tribunal is no different to this, to use a variety of forensic exercises to look for evidence that might support or establish a case from which an inferential argument might be inferred. And of course, it's a bold person that does it, but it's also open to someone to issue a witness summons, even against a witness who one might hope, whom one might be concerned might not be advantageous to one, but at least for the purpose of establishing a particular evidential process. So a claimant has all of these particular tools available to them. In this particular case, no doubt my learned friend will say, in fairness, that the claimant was a litigant in person, although I think the tribunal noted he was a sophisticated litigant in person of a graduate background who'd researched and looked at the law quite carefully. And the Court of Appeal noted, Lord Justice Elias, that actually the way that he put his case wasn't entirely clear until it got to the hearing. Prior to that, it appeared to be a more generic attack on all 30 applications. But by the hearing, it had narrowed down to him looking at particular applications at that stage. But of course, if a claimant wanted to establish an inferential basis using these types of tools, one can see how one might do it readily in an interview process. One might look for the CV of the successful candidate. One will then look at one's own CV and the job specification. And stepping back, the sort of factor that inferentially might lead you to conclude that absent an explanation, discrimination could be concluded to have occurred is something that speaks from those facts. The classic example would be, I apply for job A, my CV looks eminently suited to job A, but the successful candidate for job A, who is of a different gender, different race, their CV appears to suggest that they are significantly underqualified or unsuitable for that particular role. Those are particular facts which of themselves, absent an explanation, might lead one to conclude that the difference between us in gender, race, or whatever protected characteristic may speak. But those tools are all there for the claimant to use. It's not simply a question of commercial litigation, you prove and establish the case, which is why we observe that if a claimant sought to establish or seek orders for that type of information, and an employer was deliberately evasive about providing that information or professed to have destroyed or obscured it, those are just the sort of factors where one might regard their conduct as being sufficiently egregious to draw an inference that they were seeking to hide something. So I took it again and one just to see that one aspect of the guidance was removed, which was a specific tool, but it has to be seen in the context of the generic existence of rules which provide for a claimant being able to look to establish evidence, an evidential inquiry, to make out the foothills of establishing their case for discrimination. Yes.
Mr. Reid, you know the relevant rules much better than me, I expect.
May I take it that when the questionnaire and statutory provision about drawing adverse inferences was repealed, the rules didn't contain and still don't contain any express provision about taking of adverse inferences?
The procedural rules,
Yeah.
no, they don't. No, I'll be correct if I'm wrong. I should say that the employment law community were somewhat surprised to see that rule removed, but there were reasons articulated as to the purpose in removing it. But there is no other specific rule. That was a specific statutory provision that applied only in the context of discrimination. There's no other inferential. So it remains entirely for the tribunal to form its own views as to whether or not particular conduct might be inferential as to concealing or revealing discrimination.
Yes, thank you.
Can I also, and in part, my Lord Briggs, to answer a question that you rhetorically raised earlier, which is why might a respondent want to lead evidence at all in relation to this exercise? And in part, this also addresses a question from Lord Leggett this morning about whether or not there might be a contest in relation to facts. Because, of course, when one looks at the totality of the facts, there may be an interest in both parties in leading evidence in relation to matters. And that became evident in the way that the burden of proof operated, particularly in a passage in the judgment of Mr. Justice Elias, as he then was, in a case called Lang and Manchester City Council. I wonder if I could ask you briefly to turn that up. It's page 687. It's another case in the evolutionary process of the burden of proof. And in this particular case, the argument was being advanced effectively. Not only did the tribunal have to ignore the existence of an explanation, but it also effectively had to ignore any evidence from the respondents that might not be supportive of the claimant's case. And if you paragraph 59 and 60, paragraph 59 and 60, Mr. Justice Elias, as he then was, draws a distinction between the explanation and the facts, because the facts are concerned with looking at the totality of events, and the respondent may have an active interest in looking at leading direct evidence on the facts. And this is really my Lord Leggett's point about if there's a dispute. So if there's a dispute of fact about whether or not in an interview the interviewer had made a racially discriminatory remark, if that fact were proven to be true, that's clearly a strikingly inferential fact for the purpose that discrimination has occurred. But we won't know whether that fact is a fact unless the tribunal is engaged on an evidential exercise to decide whether it is a fact or not. And if your lordships look at paragraph 64, you'll see that this is the very point that Mr. Justice Elias then makes about what a respondent might do evidentially. So the point I'm making here is that it became clear that the wording that used to be present of the claimant establishing facts wasn't a fetter to stop the facts being looked at more generally, because it was going to be important, if there was a factual dispute, to hear both parties' side and determine those particular facts before one stepped back and undertake undertook the exercise of considering whether or not from those facts inferences could be drawn. That's a employer giving evidence to contradict a basic fact. Another example might be, which is not uncommon, for an employer to lead evidence of what is sometimes called a reverse comparator. So again, going back to my example, I apply for a job and I don't get an interview at all, and I complain that others have been interviewed who have a different racial characteristic to me. The employer might lead evidence to show that there are other individuals who share the same racial characteristics as me who were also not invited for interview. And that's evidence of a comparator to show on the facts that it may be improper to infer that my ethnicity had any impact on selection. Now, I make that point because in answer to Lord Briggs's point this morning, there are reasons why an employer might want to positively lead evidence at the stage of inferential inquiry. And in a sense, that really explains why section 136 simply starts from that proposition of saying, look at the facts. And that is the place that the law had got to as a result of Barton, Egan, and then Lang, and finally, in perhaps its full fulfillment, Madarasi, where the guidance was effectively saying to the tribunal, make your findings of fact, and then look at the findings of fact, ignoring any explanation that hypothetically holding any explanation away from your mind, from the employer, to say from these findings of fact, could we infer that the protected characteristic is the particular reason for treatment here? But that was an exercise that had to be done from evidence from all parties, not only the claimant, but also the respondent. And I've made the point already that the respondent's evidence might actually be a positive for the claimant. So without going to the respective sections, in the judgment, I've already alluded to the fact that the claimant's case in this case for discrimination here succeeded in two respects. He succeeded in a separate claim that he'd been harassed about refusing permission to go to a wedding, totally unrelated to his job applications. And having brought his tribunal claim, he succeeded in a claim that he'd been victimised as a result of a disciplinary process because he brought his discrimination claim. Now, in both of those findings, they're to be found in the Employment Tribunal judgment for your reference at paragraphs from paragraph 2.29. If your lordships wanted to turn it up, it's at page 218 in the bundle. Sorry, 2.219. It's 2.29. You'll see there's a paragraph that begins 2.29. The claimant complains of harassment in relation to not being able to attend a wedding on the 25th of April. That claim succeeded, and without going through the recital of facts in relation to that, if you turn to page 220, you'll see that at 2.296, the pivotal point in relation to that for the tribunal was that they heard an explanation from a witness from the respondents about why it was that the claimant had not been allowed to leave work to attend the wedding, and they didn't believe that witness's evidence. And then, having not believed the witness's evidence and having found detrimental treatment and the claimant's racial characteristic, they concluded that there was information which was capable of giving rise to an inference of discrimination in that particular context. And of course, having rejected the witness's explanation, they found that to be proven. To the same effect, without going into the level of detail, you'll see at paragraph 230, the claimant also succeeded, as I indicated, in a complaint based around victimisation after he brought his original complaint about the job applications. Now, my only point in relation to this is that the need to look at all the evidence includes the evidence of the respondent for good and bad, it's true. Because if the tribunal finds evidence not to be credible or rejects it, then that may be the basis of the drawing of an inference. But all of that background effectively came together in the guidance which was set out in Madarasi, and Madarasi really articulated again the factors that you've seen in Egan and Wong, and really made it absolutely clear that the facts embraced all of the circumstances that the tribunal had made findings about before one undertook the mental exercise of considering whether or not inferences could be drawn. I do, however, draw, before leaving that history, I do draw one important further observation out of Madarasi, and of course I appreciate that this is at the level of the Court of Appeal, but in Madarasi, and can I briefly take you to the relevant passage? You find it. You find the judgment in Madarasi at. I'm sorry.
Mr. Reid, once you've done that, Lord Legate will have a question for you. If you complete your discussion of Madarasi, then allow Lord Legate to ask you a question. Thank you.
Thank you very much. If I can take you to Madarasi, and you find that at the case begins at page 695. But the paragraph two paragraphs I just wish to take you to are in the judgment of Lord Justice Mummery, and in particular paragraphs 54 and 56.
What's the electronic page of those paragraphs?
706.
Thank you.
You'll see from paragraph 54 that the appellant's case in Madarasi was to boldly push the burden of proof a little bit further, in that the argument that was being advanced was that all that was necessary to shift the burden of proof was to establish a difference in status, race, sexual orientation, religious belief, disability, whatever the relevant criteria, and a difference in treatment. And of course, the difference in treatment could be not getting a job application. And so the bolder case had been that was enough to shift the burden of proof. In a sense, that's exactly what my learned friend, as I indicate, is trying to articulate here, that really this is where one lands. And the Court of Appeal rightly rejected that, and that what remains, and we say remains in 136, is that a bare assertion of discriminatory treatment, a bare assertion based simply upon a difference in status, or indeed simply upon having suffered a detriment with the difference in treatment, isn't enough to establish the inferential burden. It's still an application of the statutory test, but as at paragraph 56, Lord Justice Mummery was articulating it, you need to find more in the facts for that inference to be operated. We say that nothing's changed in section 136 from that being a fundamental proposition, about the way that one approaches the law of discrimination, even with the burden of proof under section 136. I apologise, Lord Legate, I missed your hand, so I am sorry.
That's quite all right. I was just going to ask for your observations about the point I put before lunch, Mr. Quomey, in terms of one way of looking at it being possibly the distinction between the legal and evidential burden of proof, which in the textbooks is drawn as the legal burden of proof is if there's uncertainty or insufficient evidence on a particular point, it's decided against the person who has the legal burden of proof. The evidential burden is a burden to adduce evidence capable of proving a particular matter. And if you don't discharge that, your claim fails. And the classic example would be in a criminal case. If you don't put forward to the prosecution sufficient evidence, your case doesn't get to the jury. It's no case to answer. And here's one way of looking at this, is that the change in wording is designed to make clear that the claimant, although he has the legal burden of proof on stage one, he does not have an evidential burden. He does not have to adduce evidence to prove particular facts. I mean, he may in practice, if he doesn't do that, he may not get through to stage two, but it's not incumbent on him to adduce evidence so that his claim fails if he doesn't. In principle, he can get through the gateway, if you like, to stage two of evidence that the respondent calls or fails to call. In other words, there's no duty on the claimant to produce evidence, failing which his claim gets knocked out.
Well, I'm slightly cautious about accepting that as completely as a proposition for this reason. And I suppose it's in part answered by the way you articulate the question. A claimant, if they fail to adduce any evidence at a particular hearing, and there is no evidence from the respondent that would form the basis, will not succeed in their claim. And there is a legal burden in the sense that if a claimant asserts that they have been discriminated against, they clearly have to succeed in that legal burden of establishing that they have been discriminated against to be subject to the remedies. And I agree that at the evidential level, it's a question of choice what evidence the claimant leads, and there is no specific obligation upon them to lead any particular evidence. But it's going to be difficult for a claimant ever to succeed unless there is evidence that they can point to give rise to the inference.
Well, that's obviously true. If there isn't evidence, and normally, obviously, the claimant's going to have to put it forward because the respondent isn't likely to be putting forward, in the ordinary course, evidence against themselves.
Yes.
But there's no rule that if you, at half time, as it were, if you haven't put forward enough evidence, your claim fails. That's not what this is intended to demonstrate.
Yes, well, in fact, I perhaps don't need to take you there, and Mr. Quomey will disagree if he disagrees with this proposition. There's a body of case law in the context of discrimination that tribunals should be very slow to determine a case, as it were, at half time. Obviously, in normal civil or forensic litigation, commercial litigation, if someone hadn't proved a critical fact, you'd stand up and take your courage in their hands in the old days of making a submission to no case to answer at that particular point in time. If you try that in the employment tribunal, the tribunal will look at you askance because they will have some expectation that there will be evidence. That doesn't mean that there aren't cases where the tribunal has the power to strike out, for example, that there's a case that has no reasonable prospect of success. It also has the power to order a claimant to pay a deposit if it considers that a case has little prospect of success, which may mean that they might be subject to a costs order if they proceed and fail. So, for example, if I simply made a bare allegation of discrimination and I led no evidence at all, I didn't even particularize any semblance of a basis for why I said that was discrimination, I might find myself at risk of having that claim struck out. But if I have some semblance of a case, even if it isn't sufficient for there to be an inference to be drawn, the typical practice is that a tribunal will not hear a no case to answer. It will turn and hear evidence from the employer. But the reverse of your proposition is there is no specific obligation on the employer equally to lead any particular evidence that it chooses to. They are going to have to make a forensic judgment as to what evidence they would need to call to meet the case they face. So bare assertion of discrimination, no supporting evidence. Do I need to call every single decision maker who's engaged in this process, or do I take the view that there isn't evidence upon which the tribunal is likely to conclude that an inference can be drawn? I'm afraid that's a very long answer to your point. I'm sorry.
Yes. The fact that you've made such a long answer to the point leads me to suggest that it might be easier, rather than worrying about whether we analyze this as a distinction between legal burden and evidential burden, just to keep it at the simple level that Madrassi says that the tribunal can look at the evidence not only of the claimant, but also of the respondent at stage 1. And it strikes me the busy practitioner would perhaps grasp that more quickly than having to go through the contortions of when there's an evidential burden and when there isn't. But I'd be interested in your comment on that.
Well, it perhaps follows from my primary submissions that we regard the guidance in Madrassi as remaining good as and while obviously with the greatest respect to Lord Leggett's analysis, which is more forensically legal about the approach, one has to recognise that the tribunals are dealing in many cases with litigants in person, yes, who need to understand the case that they have to advance in plain terms. And one of the advantages of the Equality Act is that it did seek to recast things in a way that made it easier to understand. So, yes, my own friends already referred to the fact that what was originally, say, discrimination becomes articulated because of a characteristic, so that people could readily understand what direct discrimination might mean. And 136, my submission is, or our submission is, really only articulates in straightforward terms the statutory test that the articulation in Madrassi made perfectly plain is, look at everything.
That really is the point I was making. We are dealing in tribunals with litigants in person. And it seems to me that an analysis which says, look at everything, is probably easier for the claimant to grasp than the distinctions between legal and evidential burdens.
Yes. My Lord Briggs had a question. I think, my Lord, if I've answered your question sufficiently.
It was a short one, Mr. Reid. The practice of making a submission of no case to answer at half-time in civil proceedings went out of fashion rather fast when the court introduced a requirement to give an undertaking not to call evidence if your submission failed. And I wondered if the same rule applied in the employment tribunal.
No, it doesn't. And I well remember as a junior having my robe tugged by an associate to make a no case, and the judge looking at me quizzically and saying, well, are you going to lead no evidence? And in my junior days, I didn't really fully understand the question that was being put to me. But fortunately, in the employment tribunal, that's not an election you're frequently put to. It's more likely to be the case that you'll be told that your application is very unlikely to be successful and don't trouble to make it.
Thank you.
I think that's taken me through Madrassi, and almost essentially I come to this point, which is that we take from 136 really just a plain speaking articulation of that question. I rather bluntly put it as being look at everything, but that is the mandate which the tribunal has to look at. Obviously, it will have had an exercise of control in directions or exercise to manage the evidential limits of what it is looking at. And the parties are choosing the evidence before the tribunal that it's determining that question, but then it looks at all that evidence together. And that, we say, is the consequence of Madarasi, and that, we say, is all that 136 in its modified form requires. I've already indicated that in approaching the question of the change of 136, in our section 136, we mirrored in large part the reasoning of Lord Justice Singh in the Adeyemo case, and in our appellant's case, we look at some of the features that he identified. It's worth noticing that in that case, and it may explain perhaps why Lord Justice Singh did rather more research from the bench than might otherwise have been the case, that the respondent wasn't represented in that case. The respondent had become insolvent and had got into administration, and the appellant was in person before the court. Sorry, the appellant was represented, so rather reverse of the normal case. And so Lord Justice Singh seems to have looked at a number of factors, absent submissions perhaps from a respondent, to consider whether or not the intention of Parliament was to make a substantive change in the burden of proof. And the factors which we draw support from, and I accept, of course, that none of them in themselves are specifically telling, are that the explanatory notes to the Act, and for the purposes of your reference, perhaps rather than taking you to the relevant passage, you find it at paragraph 116 in the respondent's case. Sorry, page 116 in the respondent's case. The explanatory notes to the Act articulate section 136 in exactly the same way as the burden of proof had operated under the predecessor legislation. Lord Justice Singh looked at, and this is within his judgment at paragraph 97 in the subsequent paragraphs. And I don't propose to take you to that, but to make the point, because I note that no counter argument is advanced against this. He looked at all the consultation papers leading up to the Quality Act in 2010 and noted that none of them identified any specific mischief about the burden of proof that had been applied or operated. And at page 117 in the electronic bundle, we cite a passage from Lord Justice Singh's judgment at paragraph 97, where he refers to the consultative background to the Equality Act 2010 and notes that there was very little reference to the burden of proof, other than that what happened is that they extended the scope of the application of the burden of proof to some areas that it hadn't applied to before. For example, goods and services. So domestic legislation on discrimination in goods and services didn't have a European route. The European directive on the burden of proof didn't apply to the provision of goods and services, in which for many years, of course, it had been unlawful to discriminate against. One thinks back to the Alvino case many years ago. And the Equality Act extended the scope of the burden of proof to those areas. But that appears only to be the only express reference, that and a reference to how the burden of proof might operate in relation to equal pay disputes. So nothing suggested a particular mischief or concern. Perhaps more importantly, nothing suggested a problem in the way that tribunals day in, day out have been applying this guidance in determining cases. At paragraph 117, and I appreciate that it's only an aid in exceptional circumstances to interpretation, but a review of Hansard reveals nothing in the passage of the Equality Bill that suggests any particular conscious decision to change. And Lord Justice Singh reviewed, and we set this out at paragraph D in our case at 117. There's obviously a body of academic commentary and also commentary by learned practitioners about the legislation. And again, none of that suggested that anyone thought that there had been any material change in the way that the law had operated. Yes, I'm sorry.
I'd be correct in saying I think the explanatory note to which you refer was a post-enactment note produced by the government department and the Equalities Office, rather than material put before the parliamentarians at the time that they were considering the legislation.
I apologise, I ought to know the answer to that question, and I'm afraid that I don't.
Well, if you look at page 1197, the answer is there. These explanatory notes have been prepared by the Government Equalities Office, the Department for Work and Pensions, etc., etc. So this is a different document from an explanatory note which accompanies draft legislation which goes before Parliament, and this accordingly has a different status.
Yes, well, and I accept that it's a point perhaps which carries little weight other than with the passage of the Act itself. And my learned friend will always say one looks at the specific wording. What perhaps carries more weight is the Equality and Human Rights Commission's statutory code of practice, which we note at little paragraph E on page 117. And the Equality and Human Rights Commission has a role of producing statutory guidance in relation to the application and operation of the legislation. And you find that at page 1239. I should say that this was produced in 2015. I apologise, 2011. And then we have the guidance beginning at page 1239, and the relevant sections are at page 1242, paragraph 15.32, through to paragraph 15.36. And the guidance provides explanation from the Equality and Human Rights Commission as to how the burden of proof should be applied, and the examples, we say, reflect exactly the approach that pre-existed under Madarasi, which remains which appears to be consistently applied in the guidance following on. The examples perhaps make good my point about the need for there to be matters which speak of discrimination beyond mere status and detrimental treatment. So stepping back, we respectfully agree, and with Lord Justice Singh in the Court of Appeal in Ayodele, that the purpose appears to be from the legislation merely to articulate and tidy up in plain language the fact that one needed to look at all the facts, and not an intention to substantively change. But before leaving this, could I just address one argument my learned friend places weight upon? and that's to draw a comparison with unfair dismissal. And you'll recollect that he says, well, neutral, and that is in a sense a loaded term in some respects, neutral burdens of proof can be found. And he gives the example of the Employment Rights Act and unfair dismissal and section 98 of that act, where the tribunal, in determining whether or not a dismissal is fair or unfair, for your convenience, you'll find it in our case at page 119. We set out the relevant section, page 119 of the electronic bundle. You'll, in the context of unfair dismissal, if a tribunal's found that there's been a dismissal, and that the employer has shown that there is a potentially fair reason for that dismissal, the tribunal moves to this stage of determining whether or not the reason, it's subparagraph 2, subparagraph 1 is whether or not the dismissal is fair or unfair. Firstly, the employer showing the reason, and then finally, subparagraph 4, the tribunal determines whether or not the dismissal is fair or unfair, having regard to a number of factors. That's on the next page, 120. And that is said to be neutral. That's true. But of course, what this ignores is the underlying factual substratum, that before you ever get to this, a claimant has got to show, A, that they're an employee. So we know that status has been a vexing topic in the court, and of course this court itself in recent times. They then have to show that they have got the necessary qualifying service of 2 years. There are certain cases where you can succeed in unfair dismissal if the reason in itself is a prohibited reason, but there's a need to actually show that's the reason for your dismissal. And finally, there may be an evidential dispute about whether or not someone's dismissed. The classic example being constructive dismissal. I want to bring an unfair dismissal claim and I've resigned, but the employer resists to say, well, you simply resigned. I need to show that it was a constructive dismissal, that there were facts that justified myself as being treated as being dismissed. So I only make the point that it's wrong to draw an analogy with unfair dismissal because it ignores the fact that there's a substratum of fact and evidence that has to be determined in any unfair dismissal case. I apologise, my Lord Legate.
Yes, it really may fit in with what you've just been saying, but I can't see that burden of proof comes into it really with subsection 4 here, because burden of proof is surely about what happens if you haven't got evidence of a fact, and you've got to have some rule that decides whether you treat the fact as existing or not existing. But whether something's fair or not, you don't need any burden of proof. You just make up your mind whether it's fair or unfair.
Yes, that's right. Although obviously you have to determine that question against facts, as Section 4 makes clear. For example, the size and resources of the employer. But it's absolutely right. That section is a question that isn't resident of a burden of proof. I'm only slight hesitance in answering that is that the way that Section 98.4 has been interpreted over the years is it's not an objective question. It's long settled that the tribunal approaches it on the basis of whether or not the employer's decision fell within a range of reasonable responses to dismiss. Some may disagree with that, but that's the way the law is articulated. However you view it, it clearly isn't about a burden. So we simply say that the analogy with unfair dismissal really isn't helpful at all. And actually, we should just be getting back to the simple proposition that the legislation makes clear what was clear before under Madarasi, and tribunals should not in any way desist from approaching the questions in the way that they have for a substantial period of time, of looking at the facts in the total and then seeking whether or not to conclude that they could properly infer. That's all I really wanted to say about section B. My learned friend said in his introductory remarks that his appeal would succeed on ground 2, even if he was unsuccessful in ground 1. It comes as no surprise that we look at his ground 2 and perceive it to be really no more than a perversity appeal being advanced in relation to this particular case before your lordships. If you look at the application in this case of the tribunal's reasoning, one can see that the tribunal directed itself, and can I say that we deal with this from paragraph 39 of our case. That's at page 121 of the electric bundle. We look at section 136 in this particular case, and we see that the tribunal self-directed itself. Now, I acknowledge that they use the language of proving facts, but they were looking at it from the point of view of the facts before it, and it's quite clear that the tribunal looked at all of the facts and considered whether or not on those facts it could conclude that there was discrimination. And it did that having received guidance as to Madarasi, Barton and Egan, and in the way that tribunals were very familiar with approaching those particular questions. I say in answering it, a question earlier, I think a question was phrased earlier as to when the argument about section 136 having changed the law first appeared. I didn't appear below, and in fact none of my juniors did. A solicitor from my instructing solicitors appeared in the EAT, and we've asked him, and we think it may be that counsel who represented pro bono the claimant raised the issue in front of the EAT, but it certainly wasn't raised at the level of the employment tribunal, where there appears to be unanimity between the claimant and the respondents about the approach to be taken, and the tribunal itself notes that it wasn't necessary for it to re-articulate the law because everyone agreed as to the approach to be taken. So the tribunal properly directed itself as to the law, and my learned friend's argument then effectively, as we say, becomes a perversity argument. And really, it centres on two things. The second ground of his appeal, which we'll come on to, the idea that there was a positive obligation to lead evidence and an adverse inference could be drawn. But the other aspect of his case is really the high watermark that the tribunal were wrong in articulating, that there was no evidence about the race of some of the successful candidates. And we deal with this at paragraph 44, page 123 of the electronic bundle. And it's certainly true that there was some evidence. Of the 30 job applications, there was evidence, I think, in relation to 7 of those successful candidates, where in 6 cases there was evidence of them being born in the United Kingdom, and in 1 case, one of the individuals being born in India. That didn't necessarily mean that they were not of Black African origin, but there was some evidence there. But the problem that my learned friend has is, what does that speak of? If one adopts the approach in Madarasi, the fact that there is a difference in status between the claimant and any of the successful candidates is not of itself sufficient to give rise to the inference of discrimination. If the claimant had tailored his case to say, here's my CV, look at the CV of a successful candidate, and there's evidence before the tribunal that they had access, there was evidence before the tribunal of the CVs of successful candidates, or look at my job CV and look at the specification for this, and you can see that I was eminently suited to a particular role, there may have been a case in relation to that. But clearly, the tribunal looked at the evidence that was being led and concluded that wasn't the case. And that, to use the language of a dial, even if it had been the case that they'd focused upon the fact that there may have been a difference in race between the successful candidates and the claimant, that wouldn't have been enough to move the dial to say of itself discrimination would be inferred in this particular context. That's Madarassi. So we say that at its absolute highest, that point doesn't really lead to a conclusion that you can draw an inference in relation to this. And the tribunal were entitled to reach the conclusion they did. I'll come on to some points which Lady Justice Lang, as she was at the time of the AT, addressed. But can I move on then to our ground C? And our ground C is the alleged failure to draw an adverse inference. And essentially, this is the argument to say that there was a positive obligation on the respondent to lead evidence from each of the recruiters or managers involved in the decision-making process. And if it didn't, an adverse inference should be made against it. I'm not going to repeat my earlier remarks about how that would be a revolutionary stance in terms of effectively placing a burden upon an employer consciously to call evidence in every case of a positive assertion. But what is noticeable here, and our case in this respect begins at page 124, is if one looks at even at the high watermark of my learned friend's case, one says that there was a specific need for the employer to call all of the recruiters and all of the managers who were involved in each of the 30 decisions going back over the 4 years, and that absent that, inferences could be drawn. Inferences of what? We articulate this at paragraph 48 of our case because we're not really told by the appellants what inference should be drawn from the failure to call people. Is it an inference that all the successful candidates didn't share the same race as the appellant? It wouldn't really tell us that. Is it an inference that all of the people involved in the recruiting process knew the appellant's race? Again, it wouldn't really tell us that. And perhaps most importantly, it wouldn't tell us of itself the reason for the rejection of their particular job. So even if my learned friend is articulating to say, well, there was some form of obligation, unless he can say that the obligation means immediately you fail to discharge the burden of proof and discrimination must be proven, the failure to cause any particular witness doesn't automatically lead to any particular inference in this particular case. And you can see, we say, that what the tribunal did here is look at a wide variety of factors and in addressing those, form the view not only that it couldn't infer that discrimination was the reason for the refusal of the applications, but actually it went further, and that's we'll address in section D, that actually went further and positively concluded that the claimant's race was not the reason. Can I just briefly take you through, and I'm not going to repeat them extensively, but if I direct your attention to paragraph 52 on page 126, And we note that it's necessary to look at the context of the respondent not leading each of the decision makers. And that context was evident in a number of respects. Firstly, that the claimant came to the tribunal effectively arguing that there was a form of conspiracy against him, and really it only became clear in the course of his case that he was alleging each individual application was a freestanding act of discrimination. That having been said, what the tribunal had before it was a wealth of material, and we address this at paragraph B on page 127, that's 52B, just summarising those points. It had information about his CV, which the tribunal found to be generic and not really adapted to any particular job applications. The tribunal had evidence of the successful CVs of successful candidates. He had evidence of feedback that had been given to the claimant about why his applications hadn't been successful. And it also had the fact that he'd been unsuccessful in the online talent queue process, which had tested his assessment for suitable roles. So it had a variety of pieces of information, all of which it could look at in considering whether or not discrimination could be inferred. And in that context, as I say, that there's a forensic view being taken, by the respondent, that it wouldn't be profitable to seek to witness summons or track down, even if available, every single recruiter or manager involved in that decision making over a 4-year process, when the material that was available on paper in the process showed no case to infer that discrimination had been the reason. And the tribunal also noted, as I say, at little d, that the claimant's case had been really that there was a wide-scale conspiracy against him involving, this is at little c, involving deceit and fraudulent changes to documents up to and including the trial bundle. That's on page 127 of the electronic bundle. And the tribunal found that to be lacking any credence or credulity. So the tribunal was looking at all the facts together to form a view. Now, my learned friend's critical of the fact that Royal Mail led witness evidence from Mr. Hames and Miss Hancock, this is at little d, who were people engaged in respectively separate managerial recruitment and technical recruitment, who weren't directly involved in giving evidence, in the decisions on the claimant's applications. But they clearly gave evidence that the tribunal accepted to be cogent and credible about the processes that Royal Mail operated and the shortcomings of the claimant's evidence in relation to that. So those were all factors that the tribunal in the round reached the permissible conclusion that it couldn't infer that discrimination was the reason for the rejection of the complaints. Now, I should just pause there to note, and we deal with this at page 128 in our case. My learned friend referred you to a passage in the judgment of Lady Justice Lang, in this case before the EAT, where she looked at a variety of factors that she said might have led to an inference being drawn. We've already made the point in our case that perversity challenges really have to be clear, because it's a dangerous exercise to undertake an inferential exercise at an appellant level. With greatest respect to the court, of course, those engaged at first instance in dealing with the evidence are most able to determine the question of inference. But looking at those factors and how they are addressed, at page 128, we apologise. Do you Apologise, my keyboard fell over. Page 128, little f, we run through some of the factors that Lady Justice Lang, Lady Lang, she then was in the AT, looked at as being properly inferential. She identified the fact that the claimant was of Black African origin. And of course, we're back to that problem that simply identifying less favourable treatment and having a protected characteristic doesn't give rise to a case to answer. It's clearly going to be an element in forming a view of inferential treatment, because you're not going to have a basis for inferential treatment unless that's the case. But that of itself, as Madarassi made clear, isn't sufficient. The other factors that were pointed to, and my learned friend points to, are the fact that, as I've articulated, the claimant succeeded in two separate cases. This is little Roman 2, two separate cases of victimisation and harassment. But neither of those claims, which were successful, related to any of the managers or recruiters who were involved in the job application process. They related to his work as a frontline postman. And so they had no bearing or impact on the wider factual analysis. The only way in which they might have been relied upon is if there was a case being advanced that there was some form of institutional racism within the totality of the organisation, and those factors spoke of the existence of that. But that wasn't the case that was being advanced. So the success of those claims had no bearing on that particular feature. And my learned friend indicated that he added to the list of inferential factors the code of practice and the fact that the tribunal accepted the claimant's evidence that he believed that there was nepotism and cronyism in relation to the successful appointment of candidates within Royal Mail. Well, of course, that's something which raises concern in terms of the fairness of a process, but that doesn't of itself dictate the inference of there being discriminatory treatment. So we round on this by saying that, viewed as a whole, the tribunal itself properly directed itself as to the test, looked at a variety of factors and evidence pointed to by the claimant, and concluded that there wasn't a basis for that evidential inference. And ultimately, that's a decision of fact that was open to the employment tribunal to make. Can I then move on? And I think I can probably deal with this relatively succinctly. My learned friend places weight in a number of respects on a slightly wider jurisprudential basis for why you should be able to draw an inference if someone doesn't call a witness. He took you to that argument in one place, but his appellant's case deals with it in another. The first he took you to was in the Meister case of the Court of Justice. And for convenience, to save time and to save your lordships turning it up again, at page 132 in our case, we include a passage from that judgment that my learned friend took you to, so paragraph 58 of our case, and in paragraph 47. And all that can be seen that the Court of Justice was saying in the context of burden of proof was that there was no positive obligation on an employer to provide an explanation to why a candidate had been unsuccessful in a job application. But they do recognise the possibility that the refusal might be a factor taken into account. And as I've indicated, one could imagine many circumstances where that might be right. If, for example, the employer clearly gives feedback about why a candidate is unsuccessful, and it's apparent that that feedback was given to candidates of a different ethnicity, but not to the applicant, the failure to provide that information is quite clearly inferentially something that might lead you to conclude that race had a feature in relation to it. All the Court of Justice appear to be articulating is that there is a breadth of available inference that's open to a domestic court to look at all the facts. One can't translate it into an obligation to provide positive information. My learned friend then, in his case, but not presumably through issues of time, directed your attention to a number of passages. I'm sure I'm going to mispronounce this, but I'm going to attempt it as being Wisniewski and Central Manchester Health Authority. I suspect that's probably wrong, but he directed your attention to that case and the relevant passage that we include at paragraph 62 of our case and page 133 of the page 133 of the electronic bundle. And we perhaps don't need to go to the facts. It was a medical negligence case, and the issue in the medical negligence case that went to the Court of Appeal was that there had been a conscious decision not to call a particular doctor in relation to what was alleged to be negligent treatment. There was an issue about whether or not the negligence rested with the nurse or the doctor in the way that a treatment was applied. And in that context, there was a consideration of whether or not the absence of a silence of a witness might lead to an inference. Well, we say this case really doesn't assist you in approaching the burden of proof specifically in relation to this case, because ultimately what's quite clear, and we put particular emphasis on subparagraph 3 of the passage that's been quoted, that's on Digital Bundle 134. There must, however, be some evidence, however weak, adduced by the former on the matter in question before the court is entitled to draw the desired inference. The court, in other words, must be a case to answer on the issue. Well, effectively, we say that's really no different from the burden of proof as applied in the context of the Equality Act here. Is there on the evidence something where one can see that there is an inference that needs to be answered? And as a forensic exercise, it doesn't elevate a position whereby there is a positive duty to call particular witnesses in every case. It's clearly fact sensitive. To the same effect, my learned friend relies upon the judgment of Lord Sumption in Preston Prest. And again, without spending extensive time in relation to it, we deal with that at paragraph 64 of our respondent's case and page 135. And again, Preston Prest was a case about largely concerned with the with piercing the corporate veil, but primarily in one respect concerned with ancillary relief proceedings in circumstances where there had been a wholesale refusal of the company to provide financial information that might have concealed the true financial position of the husband in the ancillary relief position. And that is something which Lord Sumption, I think he's alone in addressing this particular point in relation to the case, looks at the circumstances as giving rise to a prima facie case that actually there's a need to answer the evidence. Again, these are forensic tools that might be deployed in any particular case, but don't dictate the existence of any particular rule. So we say, looking at those domestic cases, really they don't translate into any obligation on a respondent to call particular evidence unless required or compelled by order of the tribunal to do so. But of course they do mean that an employer has to make a forensic decision. What's the case I have to meet? What evidence do I choose to adduce to meet it? And if in fact I find that the tribunal has concluded that inferences can be drawn, if I haven't led evidence which meets that case, I will find that I will lose, because the tribunal will conclude that I haven't discharged the burden of proof against me. And really that's the point that Lord Justice Elias was making in the Court of Appeal below. And my learned friend seeks to elevate his remarks to being an exclusionary rule, to say you can never look at the absence of evidence from the respondent as forming the basis for an inference. That the relevant passage he points to is paragraphs 44 and 45, which we set out for your convenience at page 138 of our electronic case. We say that's to misread what's being said. What's being said here is specifically to look at the fact that there are no particular circumstances in the case of deliberate obstruction or refusal to provide evidence, and merely all one has is a forensic decision not to call particular witnesses. And one shouldn't read Lord Justice Elias as articulating an exclusionary rule, because I do acknowledge if it was an exclusionary rule, that would be inconsistent with what section 136 is telling us to do, which is to look at all the facts. But this is an appeal ultimately against the tribunal decision. And while I say that that's a misinterpretation of Lord Justice Elias's judgment in the Court of Appeal, it doesn't matter if in fact, when one looks at the tribunal decision, it's quite clear that they did exactly what they were mandated to do, of looking at all the circumstances and forming a view as to the totality of the case. Can I then move to the last and final section of our case, which essentially says this: even if it were the case that the tribunal had concluded that the burden of proof switched, we find in the tribunal's judgment that it had reached a conclusion that actually the reason for the treatment of the claimant in the rejection of his applications was not his race. And of course, ultimately, the question of the reason for the treatment is the ultimate question that always has to be answered. That's the forensic issue before the tribunal. The burden of proof is a tool in that armoury, but as was made clear in Shamoon in the House of Lords, sometimes the burden of proof isn't necessary. The tribunal can make a direct finding on the facts as to the reason for the treatment. The burden of proof may not be of assistance in circumstances where actually it can make a positive and directed finding. And we find in this particular case, two passages in the judgment of the AT. We set them out at paragraphs 77 and 79 in the respondent's case at page 141, that one can see that the tribunal were going further than simply saying we're not satisfied that the burden of proof has been switched, but actually we find that there weren't facts upon which we conclude that the reason for his treatment was not his race. And again, that was open to the tribunal. They had the information about the generic nature of his CV. They had the information about his failure to pass the online assessment test. All of that information was open to them. So even if my learned friend was right about the burden of proof, even if he was right that it should have switched in this case, in his perversity challenge, the tribunal permissibly made findings in this case which established quite clearly that they accepted the evidence that there was no element of his refusal of the applications which was because of his race. I have an eye on the clock. Those are my formal submissions. I'm conscious of providing some time for any further questions your lordships wish to ask of me in relation to any matter?
Well, looking to my colleagues, there don't seem to be any questions coming your way, Mr. Reid. So thank you very much for your submissions.
Thank you.
Mr. Kume.
My lord, I wasn't aware that I'd switched on mute, so I hope I didn't have it on previously. I have 8 points in reply. Some of them are really quite short. The first thing I wanted to do was to summarise my position on ground one. Unfortunately, in listening to my learned friend, my note has become ultra scrappy. But the simple points I want to make are this. My learned friend said, it's just the test is just a plain speaking look at everything. Well, I agree with that, but I would add, and don't get hung up on who has to prove the facts. As I said previously, it's not a radical or fundamental change. We now appear to agree about that. I believe when we started, it was the respondent's position that it was a radical or fundamental change. It isn't. That may, of course, go some way to explaining why there isn't much mention of it, there's no mention of it in any of the legislative supporting material, because it's not a fundamental change. All we say is, surely it is desirable that tribunals up and down the land should ask themselves the question in the statute that they are applying. And the question in the statute doesn't refer to the claimant having to prove anything. And similarly, surely it's desirable that the guidance to lower courts, that currently is the Eigen guidance, should be aligned with the clear words in the statute. That's it. Of course, in some cases, it's, as I said, it's a change of emphasis. In some cases, it may not make a difference. In some other cases, it might. It might have made a difference in this case. We're not seeking to assert positively that it would have done. We've just said it might. And a change of emphasis in my submission is still a change. It may not be a very big one, but if it slightly changes the way that the tribunal approach the question, that is a change, a real change. And just before I leave this, Lady Justice Lang explained her view of the reason for the change. The page reference is page 194 in the electronic bundle, and it's at letters B to C on that page. It's in the middle of paragraph 78, which starts on the previous page. And she says there, section 136 prohibits the submission of no case to answer because it requires the tribunal to consider all the evidence, not just the claimants, and because it is explicit in not placing any initial burden on the claimant. So that was her thinking about it. But as I said, we simply say, why can't the question that the tribunal asks itself, simple question, be aligned with the statute? Moving on to my other points. Point number 2, the respondents seem to have erected a straw man and considerably exaggerated our position in relation to the significance of the absence of evidence from the respondent. And I query why it's necessary to do that if our position is so weak. A few moments ago, Mr. Reid said that our position on that was a revolutionary stance. Absolutely not. One only has to see that from his own paragraph 71. He said, I wrote here, he said earlier, the mere absence of evidence isn't sufficient to shift the burden of proof. Absolutely correct, I agree. That's not what I've been contending at all. What we've said is that absence of evidence entitles the tribunal to consider drawing adverse inferences both at stage 1 and stage 2. It doesn't mandate that they should do so. It just says they can use whatever formal forensic tools are available at any stage of their reasoning. My learned friend also said, the mere existence of a difference in status and a difference in treatment means that there is a positive duty to lead evidence from every decision maker. This was his summary of what our position is. Absolutely nothing could be further from the submission I've made. He also said, in relation, we were seeking to reinstate the failed argument in Madrasi that a mere difference in status and a difference in treatment is sufficient to shift the burden of proof. I wrote on my note, no, no, no. We accept the position that in order for the burden of proof to be shifted, you have to have the 3 elements. You have to have a difference in status, you have to have a difference in treatment, and you have to have the something else which connects the two. And section 136 doesn't change any of that. That is, the 3rd element is simply one of the facts which the tribunal must decide. They must decide whether or not that's proven. So to assert that it was repeated endlessly that we were asserting there was a positive obligation to adduce evidence, not correct. A positive obligation to lead evidence from every decision maker when there was a mere difference in treatment and difference in status. Not at all correct. All we have said is that if the respondent chooses to play tactical games, they won't just face the risk of coming undone at stage 2, as Lord Justice Elias pointed out. That is, their tactical game playing, if that's what it is something that the tribunal may, if it chooses to, it's not compelled to, take into account at stage 1 in deciding whether or not the burden of proof should shift. It's as simple as that. My learned friend said that the tribunal did not apply an exclusionary rule. They did, and I took the court to the passages at page 215 in the bundle. We looked through paragraphs 2.20 and 2.21. And although they don't say we're applying an exclusionary rule in terms, if one looks at that in my submission, that's what they're doing. They say, here are these gaps in the evidence. Oh, you, Mr. Efobi, you haven't proven your case. And we are not entitled to draw inferences or are not bound to draw inferences. They were in effect applying an exclusionary rule. The reason I took the court earlier to the crystallization of that approach in Lord Justice Elias's decision in the Court of Appeal is not because that's the first time it appears, it's just because he expresses it with sort of crystal clear clarity. And as to that passage, and it's at page 168, paragraph 44, it now appears from my learned friend's submission that the parties are in agreement. If one reads that passage, quite clearly, an exclusionary rule is being put forward by Lord Justice Elias. It's absolutely plain on its terms. He says it's not legitimate to draw an inference from the absence of evidence at stage 1. Now my learned friend appears to be agreeing with me and saying, well, that's not really what he meant there. Well, that's what he says. The true position is that if there is an absence of evidence or a failure to put forward obviously relevant witnesses by the respondent, the tribunal is entitled to draw inferences, adverse inferences from that at stage 1, if it thinks it's appropriate in the circumstances of the case. If it doesn't, then it won't. It's not limited. That forensic tool is not limited to the second stage consideration. Item 4 on my list. I'm sorry, it's just been pointed out to me that my Lord Legate had a question, and I'm afraid I didn't notice. Forgive me.
I just wanted to make sure I've understood your position. I think I have. You're not saying that the tribunal were bound to draw an adverse inference. You're just simply saying that they were entitled to if they thought it appropriate, which I think is the same as what your opponent is saying.
Yes, my Lord. That's why I said I don't think there's actually any difference between us now. And what I'm sorry.
Is the error of law, you say, the tribunal made then, that they thought that they weren't entitled to draw an inference even if they wanted to?
Yes, my Lord.
And that had they advised themselves on the law correctly, they might have thought it appropriate to draw an adverse inference, although they might not. But that's something that we can't know, and therefore we should set aside their decision and it should be remade. Is that your argument?
Yes, my Lord. I was going to go on to point 4, very small point. My learned friend took the court to EB and BA, and I just very quickly want to look back at paragraph 52 of that. It's at page 604 in the bundle, hopefully. First of all, I accept what Mr. Reed said. In paragraph 52, of course, I accept that at paragraph 51, the Court of Appeal recalled the fact that the tribunal had erred in not getting onto the second stage, and so the context that is the context in which they make the remarks at paragraph 52. I entirely accept that, but the remarks at paragraph 52 are, in my submission, not limited to the second stage of consideration. And we see that by looking in the paragraph, and it's sort of halfway through where they say this: the stance taken by the respondent may be suitable for commercial cases. In my view, it is not suitable for a difficult discrimination case. It is important, in my view, that tribunals bear in mind the objectives of Section 63A at the pre-hearing and hearing stage. And the reference to the pre-hearing stage, in my submission, indicates that these comments are to be taken as of general application. They're not confined to the particular circumstance in which they were deployed here, which was in relation to a consideration of the stage 2 question after a prima facie case had been found or should have been found. Mr. Reed, this is point number 5, Mr. Reed pointed out that it's open to a claimant to seek a witness order, as it's called in the tribunal, against a person who might appear to be a hostile witness, or not a hostile witness, an adverse witness. In other words, to seek orders from employees of the respondents. That is absolutely true. One can do that. If one has ever seen that being attempted by a litigant in person in front of an employment judge, again, without entering the arena, the judge will rightly caution the litigant about doing that, because the normal rules will apply. If you call an adverse witness, you're bound by what they say unless they can be treated as hostile. So it's not much use. And I also point out that, in fact, Mr. Efobi did try and do that. That's clear from paragraph 1 of the liability decision at page 206. He did that at the hearing, and it was refused by the tribunal. So I just wanted to draw attention to that. But I dealt with point 6 in my note already. I've got 2 other short points. The first is to just go back to the consideration of section 98(4). which my Lord Legate raised a question in relation to. I don't want to make too much of this. It's an analogy. Of course, it's not on all fours with section 136. The reason I'd referred to it in my submissions this morning is because, as I indicated, there had been a change from an express burden to a neutral burden. The Heavey case we looked at was the EAT wondering, well, how will this affect tribunal hearings in practical terms, and then realizing, well, we can just get on with things. That was the significant side relied on this morning. But there are 2 points I wanted to make in relation to this. First of all, that although in the question in section 98.4 is an overall decision as to whether the dismissal was fair or unfair, it's plain from the terms of that section and from any more than absolutely straightforward unfair dismissal case that there may well be factual issues that bear on that issue, and those need to be determined under section 98.4, and they don't have a formal burden of proof in relation to them. So it's not purely a value judgment, we say. Secondly, I just wanted to, I know I said that it had originally been an express burden. What I hadn't done earlier was to take the court to where that appears. That is at page 494 in the bundle. I'm not sure if there's a huge amount of value in turning it up, but what we could do, just to show that originally the predecessor of section 98.4 had an express burden in it. The legislative history of the section is rather complicated. Prior to being section 98.4, it was section 57.3 of the Employment Protection Consolidation Act, which I can remember because that was the position when I started in practice. So I have that ingrained in my memory. But prior to that, it appeared in a schedule to the Trade Union and Labour Relations Act 1974, and it was paragraph 8. And the previous questions were much as they are now, section 98, but subparagraph 8 said, subject to subparagraphs 4 to 7 above, the determination of the question whether the dismissal was fair or unfair, having regard to the reason shown by the employer, shall depend on whether the employer can satisfy the tribunal within the circumstances and so on. In effect, the test just placed upon the employer rather than dealt with in a neutral way. As I said, I accept that that analogy may only go so far, but there it is. I've already made that point. Right. Then my final point is, and I apologise if this sounds as if I'm sort of taking up a challenge that was laid down by Mr. Reid, but I don't mean it to sound like that. He asked sort of rhetorically, well, what are the inferences? What are these inferences that we say should be drawn? Well, there's any number of them. I've written down 4. That the recruiters did in fact look at the racial origin of Mr. Efobi. Although the tribunal accepted the evidence that, well, there was no reason to do that, they didn't actually have any evidence as to whether people did, because they didn't hear from the decision makers. Another inference is that this is something I sort of adverted to this morning, is whether there was bias in the pre-selection process. It's in no way determinative, but it may be important in shifting the burden of proof. Or an inference in relation to one of the jobs for which Mr. Efobi was best suited, such as the information security jobs, that he was not shortlisted because of his race, so he never got the chance to be interviewed. And finally, under this head, just going back to the issue of the non-calling of the employees, there is an example of one of them not only being named, this is one of the decision makers, but his name being put forward in a way which is suggestive that he was still in post. And that example is in Mr. Haskins, in Mr. Hames's statement, I believe. It's page 269 of the bundle. And it's paragraph 27 of that witness statement. And it says, Efobi was longlisted for this role by the recruiter. However, he was not shortlisted for interview, having been rejected by the recruiting manager, Mike Haskins, head of wholesale products. Now, it doesn't say he's a former employee, gives his job title. So an inference might have been drawn by the tribunal that he was still in post. And that might have led them to ask the question, well, why couldn't he give evidence? Even if he didn't turn up to the tribunal, the final point on procedure I should mention is tribunals are far more willing than civil courts to accept statements, even if witnesses don't turn up. Of course, they don't give them the same weight if witnesses are not cross-examined, but there is a much greater openness to tribunal to accept evidence on that basis, because often that's all that litigants in person will have. Unless I can assist the court further, those are my submissions.
Lady Arden.
I just wanted to ask whether you wanted to say something more about the phraseology of 136 subsection 2, which starts with the words, if there are facts. And if we just take the last point you were making about the gentleman who was mentioned in Mr. Hames's witness statement, whom it appeared might still be in employ, he was not called. So the only fact would be he was not called. Is that of itself going to be a fact from which the court could decide, in the absence of any other explanation, that a person contravened the decision, the provision in question? How does it fit into 1362, that example?
I would say that it is such a fact. He hasn't been called, and he clearly was a relevant decision maker. I don't want to suggest that any one of these small facts is sort of somehow determinative and therefore absolutely certain that the burden would have shifted. We have simply not put our case as highly as that. It's a question for the overall consideration of the tribunal. They look at all of the circumstances, but that, in my submission, is exactly the sort of fact it is a fact, and they could take account of it if they wish to, in drawing an adverse inference. They might not wish to if there had been an explanation as to why Mr. Haskins was not there, but I don't believe, I'll be corrected if I'm wrong, there was one. So that would reinforce the use of that fact in drawing an adverse inference, but it is such a fact.
Yes, I have some difficulty seeing how quite that qualifies under 1362, but no doubt you're going to leave me with that.
Well, the reason it qualifies, we say, is because he was a relevant decision maker, and it's well established in the authorities that there's no positive obligation to, but certainly one would expect to hear from relevant decision makers in a discrimination case, depending on the nature of the treatment alleged, because what is required is an inquiry into their state of mind.
Yes.
The way that if I can just step back for a moment, the way that the legislation works, and if it's helpful, I can go to the sections, but the way that the legislation works is that the respondent, i.e. RMG, is liable vicariously, and it's not common law vicarious liability, it's a statutory vicarious liability built into the Act, for the acts of its individual employees. There's a defence, a tiny defence, but otherwise, the way that liability is established is to make the respondent liable for vicariously for the acts of its individual employees. And then an individual respondent, if individuals are named, they weren't here, they become liable in a kind of loop, because they are then said to be aiding the acts of the employer. But that's perhaps an unnecessary detail. But the key point is, because of the way liability is established as vicarious liability from the acts of the employees, it's clear on the case law that one has to direct the inquiry as to why the actual decision makers, why the actual people involved did what they did, and not the organisation at large. Is that helpful, my lady?
Thank you. I'll take that away.
The sections are in the bundle. I don't know if Mr. Tompkins can help me find the relevant cases. We have all that. It's not a controversial proposition I'm putting forward, but the liability of employers is section 109 of the Equality Act, and that is at page 438 of the bundle.
Thank you.
Sorry, my Lord Legate has a question.
I mean, it really has to come down, doesn't it, to being able to draw some sort of inference. The reason why he wasn't called was that his evidence would be detrimental, because it would show that he was likely to have been racist, as opposed to all the other possible reasons. The fact that he's most unlikely to remember, and in amongst many big CVs he looked at 2 years ago, the fact that it would cost time and money to go and interview him, the fact that we think this is a weak claim, so we don't need to go around all these people. I mean, that's the sort of evaluation that would need to be made. And you'd have to think that there was some sufficient reason to think that it was wanting to hide something rather than all the other possible reasons to draw an adverse inference.
I agree. That's part of the sort of matrix of considerations that go into whether one draws an adverse inference from the non-calling of that witness. But there are two sort of important nuances. Of course, if there's an explanation as to why the person isn't there, then that would sort of militate against drawing an adverse inference. The most common one is they've left our employment. Doesn't mean you can't get them, but obviously that's a reason why it's not so easy. But your lordship mentioned, well, the time and cost of getting a witness statement from them, but this person may well have been a current employee, so that's not so, that's not such a compelling reason. And there doesn't seem to be any explanation as to why he wasn't giving evidence. So, but I agree with that nuance, but that's a process for the tribunal to go through carefully, and we say they didn't here. The other point that I wanted to make is that it's not just a question, well, the last thing they wanted was this, appalling racist in front of the tribunal. It doesn't have to be like that at all, because of the possibility of unconscious bias. It doesn't have to be that the respondent is somehow turning to, trying to shield a person that they think is going to reveal some objectionable views. It could simply be that they feel that the surrounding circumstances suggest that there might be a good suggestion of unconscious bias, and they don't want to allow that suggestion to be reinforced by having the witness present. Does that answer your lordship's point?
Thank you, yes.
Just to go back to my Lady Arden's point, and I had meant to refer to this earlier, and if I didn't, I'm sorry about that. But the importance of focusing in on the mental processes of the alleged discriminator or decision maker is made very clear in the Nagarajan case. I probably mauled the person's name. It's at page 738 of the bundle. And the relevant passages are the top of that page between letter A and B. And then the very bottom of the page, letter H, from 738 over onto 739, the whole of that paragraph.
Well, that's an important paragraph. Could I just ask you, though, while everyone's reading it, just to think how you formulate your test of when it is possible in these proceedings to draw an inference? Doesn't it have to be a necessary inference?
I'm sorry to be a bit dim. I'm not understanding why it needs to be a necessary inference. I mean, if the possibility of an inference is available and it's down to the tribunal to decide whether it's appropriate to make one, doesn't one assume that they're not going to make inappropriate inferences, and if they do, they're likely to be challenged?
So do they have to apply any test?
Well, I would say that it's an appropriate inference.
It's reasonable to suppose that, something like that.
Yes, that it's a reasonable. Yes, I'm just thinking of an expression I often use in pleadings when I say it's reasonable to infer, that there has to be an element of reasonableness to it. It can't be that the tribunal is entitled to make completely unreasonable inferences just because there is a gap in the evidence. That can't be right. So I would sort of cast it in the language of an inference that was reasonable to draw in all the circumstances.
And at stage 2, would they apply the same test?
Yes, I can't see why not.
Thank you. Thanks.
Mm-hmm.
Well, thank you very much. Mr. Reid, the questions by my colleagues elicited some further references to authority. Is there anything you wish to add at this stage?
I'm very grateful for the opportunity. There's nothing that I want to add by way of authority in respect of my submissions. Thank you.
Thank you very much. Well, the court is very grateful to counsel for their focused oral submissions, and also to those who have assisted counsel in the preparation of the appeals, not least in producing a very workable set of electronic documents. The appeal raises interesting legal arguments, which the court will have to consider with care, and the court will produce its judgment in due course. The court will now adjourn.